Hi, Benjamin Jaffe with Eskew Law. So a question we apparently get a lot is, can an OVWI be dismissed? Operating while intoxicated, DWI, DUI, whatever you call it in your state. I'm specifically talking about Indiana here and what happens here. So OVWI. Can it be dismissed? Yes. Is it common? No. That's the short answer. It is a very, very difficult type of case to get dismissed. I have had cases dismissed. I've had them dismissed on the facts of the case and demonstrating things. Generally, cases of OVWI that get dismissed are dismissed because of a technical problem the state made in the case. The most common way that I've had the cases dismissed is by winning a motion to suppress, showing that there was an improper stop of my client. One of the most recent examples I can point to is my client was swerving on the road within the lane, didn't touch any of the outside lines at all, and he was pulled over. And so the case law is really good for us on that swerving within the lane is actually not a crime or not an infractionable offense, and so you can't pull someone over for that. Now, if they touched that line or there was something more going on, there may have been enough. It was a pretty minor thing. They were kind of drifting a little and correcting. If they're like fishtailing within the line, I think it may be a little bit different. It'd be hard to stay within the lines, to be honest, but I could see a situation where it became something more, and that may give them further reason that it's somehow reckless driving or something along those lines. But generally, you're going to see a situation where there's a problem with the stop as being the quickest way to a dismissal on OVWI. The other way is that there are problems with the tests, whether that be the field sobriety tests or the testing situation of itself. If there's not proper calibration on a machine, for example, that machine's results are not going to be admissible. If an officer has not gotten certified to be a breath test operator, we've had situations like that where we've gotten cases dismissed because they can't get that information in. Now, with that being said, I have had situations where we've thrown blood test results out and or breath test results out. That does not mean the state has to throw out the case. They can still move forward based on whatever other evidence they have. And so even if they don't take a breath test, imagine a scenario where someone refuses a breath test, for example. Well, the state can still use other examples of driving behavior, field sobriety test, observations by the officer, things along those lines to try to make their case. But usually it's a technical issue that causes a problem for the state. I have had situations where the state looks at, the evidence or something, maybe there's a video or body cam of the stop, and they think it's not, maybe the officer's embellishing or misstating how someone performed or how they did on something. So I have had situations, and it's very uncommon, where you have that kind of problem. The state wants to walk away. But it is a very, very difficult charge to be dismissed. Most every jurisdiction in Indiana will not offer a diversion on an OVWI. There are a few courts that do offer sort of pretrial diversions, like conditional diversions or conditional discharges on them. I wish more courts would, but it is something that the state's pretty hell-bent on getting a conviction on these. And they don't even have to get it on the OVWI charges. A misdemeanor, oftentimes you'll see an offer to like a C misdemeanor, which seems like, wow, that's great. That's much lower. That's the lowest level of offense. The problem is that the future consequences if you get in trouble again, the consequences to your license and things like that are often the exact same. The other way we've gotten OVWI charges dismissed is through a plea agreement to something along the lines of a reckless driving. And so you get it taken out of the OVWI realm, and so it's by agreement. The only way I've had that done is when the facts for the state are really not very strong, and so you've got really good negotiating power to push for something that removes the OVWI. But that's probably the most common way I've gotten OVWI charges dismissed is through a plea agreement to a C misdemeanor driving, reckless driving or something like that. So it can happen. It's not very common, though, and the state really likes to hold on to those charges. They take them pretty seriously, even though, kind of oddly, the consequences for driving while intoxicated are not nearly as high as people, think they should be sometimes, for like multiple offenses and things like that. But in terms of getting that offense charged and a conviction, the state takes those pretty seriously, and they're hard to get rid of. Thanks.